shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honors.
Good morning. Welcome to the Appeals Court. My name is Peter Sachs. To my right, your left is Justice John Englander. To my left, your right is Justice Maureen Walsh. Will be your panel for what is now only 3 cases today. If you've been to the Appeals Court, you know there's 15 minutes per side to argue, no rebuttal. We have read your briefs. We have looked at the record. We understand the factual context of and procedural context of the case, so I would encourage you to get right to the central parts of your argument. And with that, we'll call the first case, 24P570, Commonwealth versus Harris.
Good morning, Your Honors. May it please the Court, Kevin DeMello on behalf of Mr. Harris. The lay witness in this case, Douglas Hine, was no better suited than the fact finder to identify the individual depicted in the surveillance because he only worked with Mr. Harris for a few months and then didn't see him again for 16 months before he got a chance to look at the surveillance video. The primary issue that we're arguing here is this question of familiarity of the witness. Our position is that he's a mere acquaintance here. He really only worked 30 days with this person, training him, and then after that, he only saw him from time to time over the course of a couple of months. Never saw him outside of work, and if you look at the case law, I think this case is most like the Austin case that I cited in my brief, where in that case, it's actually, I would argue, the witness was even more familiar with the person they were testifying about, because that person was a prison guard who had the defendant, work he saw them on a daily basis for 2 years, and then periodically for 3 years. And I think one of the key similarities between the Austin case and this case is you have this gap of time between the last time that this witness saw the person who's in the surveillance and the time that he is asked to look at them.
I don't recall. No, go ahead.
So let me back up for a moment. What's the standard of review?
It's abuse of discretion, Your Honor.
Okay. So tell me what the judge had before him, because there was a motion in limine, correct?
Correct.
Okay. And what could the judge properly consider as far as under pleas, the more likely than not that this lay witness could provide testimony over, that would be helpful over a fact finder as far as identification? What were the factors that the judge properly could consider?
So under the pleas doctrine, the 3 factors are the familiarity that this witness had with the individual in question, the condition of the image of the surveillance in this case, which, I don't think is a huge issue, and whether the person was disguised or their appearance had changed since the time of trial or the time that they were depicted in the surveillance. And so in this case, I think the key issue really is the familiarity piece.
The first element, the familiarity. So as far as familiarity, what did Hine have that the ordinary fact finder, whether it be a judge or a jury, wouldn't have had that advantage? That's what we're really talking about, right?
That's correct.
Okay.
And so based on the voir dire, the advantage that was claimed was that he trained this person at work for 30 days and then worked with him for another 2 months. But that was 16 months before he saw the surveillance. And again, comparing that to the Austin case, in that case, the witness had arguably much more familiarity. And in that case, the court ruled that he didn't have sufficient familiarity to testify based on the surveillance. You can contrast that with some of the cases where there was sufficient familiarity found. The pleas case itself talks about a 10-year social familiarity, and there are other cases that I cited, most of them United States District Court cases, and in those cases you have people knowing each other for 15 years, growing up together, live-in girlfriends, an ex-wife. Like, that's the level of familiarity that, at least if we look for examples in the case law, that they're talking about.
So when I read the trial transcript, and correct me where I'm wrong, and I mean that, I read Hine's testimony to say, well, he had like a horseshoe type of hairline, right? There were particular issues about the shape of his head. That hairline when you're working closely with another person and looking on the video, his eyes and the way that he carried himself.
Those,
I want this court to say the judge abused his discretion, and considering those factors to say they meet the familiarity under pleas.
so I think there's a difference between the familiarity piece and the particular features that this witness pointed out as saying that those are what I recognized. Because I agree that those particular features are what he said, that's how I can tell that this is who this is. But before we even get there, before you can even testify about that, I think the judge has to evaluate what's the level of familiarity this person has. And one of the key things from the case law, I think, is having experienced seeing this person in different contexts, you know, socially, outside of work, in different levels of appearance. And it's important in this case, this is where sort of the quality of the image comes in. The person in the image at times, at all times I believe is wearing a mask, at times he's wearing a hood. And so the question is, can someone with the level of familiarity this witness had identify someone who's wearing a mask?
But isn't I mean, everything you're talking about, sure, those are all factors, but they go into a judge's discretion as to whether to allow it, right?
They do, Your Honor, and it is a difficult standard for us to overcome. I acknowledge that, but you know, I think the argument stands that when you look at the case law.
Because I didn't, so I went and just looked at Austin because I didn't recall you focusing on Austin in your brief. And I have a hard time telling from Austin why it is that the court said that that was incorrect, right? There's not a description of what happened, but my sense is that they had a surveillance that the jury could look at themselves. And so the court was like, well, he's not really going to help because there's nothing about this video that the jury can't look at the person who's sitting in the courtroom and make a determination of equivalence. But here we have someone who deliberately tried to cause themselves not to be recognized. They put a mask on, times they wore a hood. And so there's potentially a need for someone who knows him well to identify him, right?
And I don't disagree with that.
Okay, so then that gets to the question of whether 1 month of working closely with somebody is enough to identify a person.
Well, again, you know, going back to the case law, the person has to have sufficient levels of familiarity that their testimony is going to be helpful in this case. And the problem with it, I think what sort of it's getting at is this could be a mistaken identification. Someone who's not familiar enough with someone could say, yeah, it looks kind of like him, and I'm going to say it's him. And in this case, you've got a guy who worked for them for approximately 3.5 months or so. You know, it might be a reasonable inference here that he didn't do well, you know, there as an employee, and that, you know, they're looking for a scapegoat. So I think the question of familiarity is an important threshold question before a testimony like this should be allowed. And
there's a recent case that addressed this issue, and I can't remember if it was published or not, but it involved 2 police officers who had much more limited access to a criminal defendant who was shown on a tape. Are you familiar with the case?
if I recall correctly, I do vaguely recall a unpublished case that...
It's unpublished? Okay.
That
I knew somebody on the panel. And I think we said in one instance, the person had only seen him maybe 4 or 5 times. It was still sufficient. Okay. But it's unpublished anyway.
I'm pretty sure, because I did a check before today, yesterday and this morning, to just make sure there were no other published cases. And I actually found one that is published, that's more recent, the Broom case. It doesn't really say anything different other than, you know, that's a case where you had a witness who had known the defendant for 15 years. They grew up together. The site on that is 492 Mass 585. It's a 2023 case. But again, I think it just goes to my point that the level of familiarity here isn't sufficient, and notwithstanding that there is an unpublished case that may disagree, and maybe your honors disagree, but that's our position in this case.
My memory is there was more complexity to that case. That's why I was going to ask you about it, but I couldn't remember if it was published or not. Okay.
Can I ask about the CSLI?
Yes, Your Honor.
issue? If the CSLI had showed the defendant moving south, away from the warehouse at the time that the CSLI here showed him moving north. Wouldn't you want that evidence in?
Well, it's difficult to say. Strategically, I might not, because...
Well, let's say that you did. Would the judge have the discretion to allow it?
This is a difficult argument, Judge, because
Okay.
the case law is not great for my position, and I get that. I guess what I really want to get at is that, we're seeing this type of data being used more and more frequently, that it's a significant invasion of anyone's privacy to have their location basically available to the Commonwealth anytime they are suspicious that there's a crime, and that judges should sort of scrutinize this more carefully. And here you've got a judge who said, what's even the relevance of this? It doesn't show data from the actual time of the crime. And so, we'd argue that that's shouldn't have been admitted.
If it makes you feel any better, Justice Sachs stole my thunder because I'm from Western Mass. So my hypothetical was going to be if the cell site showed they were in Western Mass at the time. So you're going to get the question anyhow. I think you handled it appropriately. But there was no objection, in fact, a stipulation, right, and an agreement that this evidence was to come in. Right? So your standard of review analysis, can you, do you want to spend any time on that or not really?
I don't know that, well, again, our position is that the judge asked about it, and the point of, the preservation of an issue is so that the judge, so it's brought to the judge's attention so they can look at the issue, and here, we'd argue the judge did. I understand it's a difficult argument to make, but that's the argument we're making.
Appreciate your...
Any other questions?
Seeing none?
With that, Your Honor, I'll rest on my brief. Thank you.
We'll hear from the Commonwealth.
Good morning, and may it please the court, Jesse Crane for the Commonwealth. The trial judge correctly exercised his discretion in admitting the lay witness opinion here. Hines was sufficiently familiar with the defendant to offer his opinion that he was depicted in the surveillance video. They worked together for roughly 3 months, 3.5 months. He was the person who hired the defendant. The 30-day training period entailed them working very closely together, 8 hours a day for 30 days. During that time, he could develop a sense of the defendant's physical characteristics, such as his hairstyle, his gait, his height. And I think it's also significant that this surveillance video was of the location where Hine became familiar with the defendant, because he could point to landmarks like shelves to say, yes, that's about the defendant's height, and make that comparison, which was helpful to the fact finder. And obviously the defendant was disguised during the robbery, always wearing a mask, almost always having a hood up. At one point, he did remove the hood, which allowed Hine to say, I recognize the top of his head, basically, and he recognized the horseshoe pattern of his hair. He also pointed to other factors like his gait, his eyes, and I think it's also significant that this was clearly someone who was very familiar with the warehouse and took a relatively small number of very high-value items. And I think that supports the inference that this was someone who was familiar with the warehouse.
But that's not the standard, though, right? So besides, it's the witness's familiarity with the defendant, right, the suspect, versus the familiarity that whoever took the items had with the premises, right? So the hex key, the kind of not hesitating and going over and grabbing, doesn't make that witness any superior to an ordinary fact finder to draw those conclusions, correct?
I think I'm getting ahead of myself and saying there would have been no prejudice even if it hadn't been properly admitted. So I will just, I guess I'll put a pin in those last few points and just say Hine was...
Well, the last point that you were making, I think is not related to a personal identification by the witness, because what you're really arguing is an inference from what he took. Sure, the witness may have something to say on that as well, but it wouldn't be based on his review of the defendant in the surveillance camera. On the other hand, watching him open the car door from the outside or watching him use the hex, I don't know, maybe that's part of an identification as well.
I would agree with that. I think the car door is, it is significant because the witness did say he drove this Jeep Cherokee with this sort of distinctive defect where he had to roll down the window and open it from the outside. So, I think that does go to the witness's perception and opinion of who's depicted in the surveillance video.
Are you familiar with the case that I was talking about?
I am. I actually believe you're referring to Commonwealth v. Belnavis.
Yeah, and didn't we reverse on part of that?
You did.
Yeah, that's what I thought.
Yes.
Because it was insufficient.
Yes, you did find
But
that.
it was about, if I recall, the one that we thought shouldn't have come in was a police officer who'd only seen the person a couple of times.
Yes, this was a published opinion, and
Okay. That's also what I thought.
I think it ties into the lay witness identification here in the sense that there was really no analogous.
How would you distinguish Belnavis, a case that we've decided within the last 6 months?
I would distinguish it on the facts that the contacts were significantly less in that case. You had 2 police officers who, it wasn't totally clear even how many times they had interacted with the defendant, and it was a relative, to the extent that it was clear, I believe it was like 2 to 4 times.
Didn't we say that one of them might have had sufficient contact, but one of them didn't?
I don't recall with enough certainty to
Neither do
tell
I,
you.
so we're in the same boat.
I should remember it. I actually argued that case, so
Okay.
I'm very familiar with it. But I think
Thought you looked familiar too.
Yeah.
I might have been able to ID you off a surveillance camera.
here I am again. Yeah, you never know. I think the big distinguishing factor in my mind between this case and Belnavis, though, is there was really no prejudice from the identification here. You had an employer who said, yeah, I trained him, I interacted with him, we spent downtime together, over the course of his 3-month employment. Whereas in Belnavis, you had 2 officers who were identified as police officers saying they were from the gang unit, and the jury heard that, obviously raising the issue of prior bad acts.
Thank you. You're reminding me now. And actually, that last piece may have been what was driving some of the thinking on that opinion, was the use of the gang references.
Right, because there's obviously the balance between the probative value of the identification and prejudice.
Got it. Okay.
And there's just no prejudice here from Hines' testimony to the defendant. I mean, beyond the fact that he's identifying him, but there's
enormous prejudice from Hines' testimony. Come on.
Well,
he worked with the guy for a month. He says, that's the guy.
It's much more probative than it is prejudicial in the sense of, bringing in irrelevant something.
I see. You mean there's no sort of prejudice, there's no sort of ancillary prejudices.
Correct.
That's what you're talking.
Yes.
Like the use of the gang. Yeah.
Correct.
Okay. I see what you mean.
Correct.
And I take your point.
I'm happy to turn to the CSLI data just briefly. I won't belabor the standard of review. I think our brief addressed it. It's substantial risk. It does show in the lead up to the crime that the defendant was nearby to the crime scene and was traveling in the direction of the crime scene. I think that has a rational tendency to establish that the defendant was the person who committed the crime.
I didn't immediately see any information about how far he was at the time the CSLI data was available and how long it would have taken him to get to the crime scene, but I could have missed it.
The record is not crystal clear on that point, and that is well taken, that it's not clear that it's exactly half an hour to get there. I think it's a reasonable inference from the map, but there's also the fact that in the September incident, you also have Hines' identification of the defendant at the crime scene through the video. So to the extent that there is that missing, explanation that it's 30 minutes, we do sort of have that additional factor establishing that the defendant was at the scene at the time of the crime. If there are no further questions, I'm happy to rest.
All right. Okay, thank you very much, both of you, for your arguments. Okay, the argument in the Nieves case, 24P854, has been postponed due to illness of defense counsel. So our next case will be number 24P838, AS versus SD. Good morning, Mr. Clardy.
Good morning, Your Honor.
Whenever
Good
you're
morning to the court. May it please the court, my name is Daniel Clardy, and I represent the appellant in this matter. I know the court's familiar with the record here. This case, as you know, arises out of an event that occurred in April of 2024.
How are you challenging the initial restraining order? I'm confused at how that gets appellate review.
It doesn't, Your Honor.
Thank you.
And so I think I really want to focus the court. I think obviously some of the evidence that was presented there that the court, to the extent the court considered it in the two-party hearing, is relevant there. But I really want to focus the court on two components of our argument. First, whether the trial court abused its discretion when it issued the restraining order in what we contend is the absence of sufficient evidence that there was a substantial likelihood of immediate danger of abuse. And I know the court is well familiar with the statute, but the abuse in this context is either attempting to cause or causing physical harm, or placing another in the fear of imminent serious physical harm. The other category is not applicable. And here at
Do you agree that the judge did not have to make specific findings as to what the reason was for granting?
I do agree that there's no obligation for the court to...
So it could have been either prong. It could have been either actual cause of physical harm or placing someone in an immediate fear.
I think that's right, Your Honor, and I think this court, again, we hope you don't, but that you could affirm on either prong if you find that there was sufficient evidence presented to the district court.
So as to the first prong, he says, the complainant says, she's been striking me and I have scars. Enough?
I don't think so, Your Honor. I don't think so. I recognize, he says, I think may have said striking, I know he says hitting me.
He's been hitting me for some time, and there's maybe at a different point in the transcript, I have scars.
Correct. He doesn't, he also says, and this was in the record, that he said he has pictures of them. He doesn't present any evidence of that. And our position, Your Honor, is that that's just not enough.
Probably wouldn't need a picture.
What?
Well, I might be wrong about that, but.
Why is it not enough?
Well,
If believed, if the judge believes that statement, why is it not enough?
Well, I guess I would point the court to the decision in the, probably going to butcher the name, the Simkowski case, where a not dissimilar type of evidence was found insufficient, where there was testimony of hitting, testimony and sort of discussion of a red mark, but no affirmative evidence was presented. I think the court said there was no affirmative evidence of any soft tissue swelling or skin bruising. So our position is that the testimony here was not enough to get over the threshold to constitute physical harm as required by the statute.
So in every restraining order, if the testimony is by affidavit, even uncontested, sorry, my male colleagues, he punched me in the mouth. That's insufficient for a judge because there's no pictures, there's no hospital records, there's just testimony of a physical assault. That's insufficient evidence? Is your position, if I follow it to its logical conclusion?
Well, I think every case, all these cases are specific to their context. If it's simply, I would say if it's simply that testimony without anything else, without sort of the context in which this alleged punch occurred, that could well be insufficient. I think the totality of the context and the information that's presented by the parties in this context is insufficient. And I think that's what the court did in Szymanski.
It appeared that the judge not only made a ruling, heard further argument, and then clarified and said, this is credibility here, counselor, my decision stands. So it appears that there are two versions of an event.
No question.
Right? And isn't that what trial judges do day in and day out?
No question. There is no doubt that the court made a credibility determination here. And in the typical case, and this court certainly gives that a lot of deference. I'll jump to the second point of my argument where I don't think that deference is limitless because here, the questioning from the court, and this goes to the other argument, the question from the court focused intently on SD's failure to make prior reports to either seek a restraining order previously, and that, in our view, is simply flatly against public policy here, because it wasn't just one loose question. In fact, during the evidentiary presentation, the only 4 questions the judge asked were focused on the failure to report prior abuse to the police, and clearly using that. I think a fair reading of the transcript here is the district court judge used those failures as a basis for the credibility determination.
I mean, so the first question actually wasn't why didn't you seek a 209A? The first question was, you didn't call the police. And it was in reference to the actions on that particular evening where she wound up, she testifies, I believe, that he hit her across the face, dragged her by her hair, and then, of course, she winds up falling 3 stories, okay? And why isn't that an entirely appropriate question for a judge to ask?
Well,
I mean, the judge is trying to evaluate the truth of what's being asserted, that these assaults happened to me on a night when I wound up in the hospital. And yet there was no call to the police saying, hey, I was assaulted.
Well, the question, it wasn't quite a question, it was a statement to counsel. The first thing was, she said nothing to the police that night. I think that's what the judge said. Now, of course,
Wait a second. Hold on, where are you reading from? Which
I believe that was Appendix 32.
Do you have a page of the transcript? Because I don't have the
Oh, I
appendix
apologize.
pages on
I
it.
can get it quickly, Your Honor. It's Appendix 32, which I believe is page 8 of the transcript.
Yeah, okay, that's right. But that's what I was referencing. That's exactly right. In other words, so he said that in response to your argument, right?
Indeed. He said it in connection with the argument I was making, and I suppose the court's interpretation of that, trying to flesh out the facts, maybe. But the court doesn't stop there. Again, this is in a context where she's being taken away by ER folks that night. I don't think there's a dispute about that. So she said nothing to the police that night. Then the next question which was later on the same page, is she's never sought a restraining order or called the police, is a question about the information that's provided about prior complaints of abuse. And then when the appellant herself is testifying on, I have it as Appendix 40, but I can point to it. I believe the transcript is page 16. Again, when she's discussing prior incidents of abuse, the court again interrupts her. It says, "You never called the police, right?" And she starts to answer. The court again says, "You never sought a restraining order before." And frankly, Your Honor, I think those questions are deeply troubling, and they appear to be the basis, a core basis of the credibility determination that I agree that this court would ordinarily give quite a bit of deference to when we're dealing with credibility. But
So you think that as a matter of the policy, the public policy that's reflected in the statute itself, right?
I think it's a fair
we
inference.
should, reading the questions asked by the judge, determine that the judge violated public policy.
I think that's right. I mean, I think that's a fair reading of the statute. To be clear, the statute, I think it's Section 3 of the statute, talks about the, treatment of consideration of the failure to make prior complaints. And so I'm asking for an
Shall not be the sole basis, is the language
Correct.
of the statute, right? And of course, we don't know what the basis was here because we don't have specific findings. We have these references, these questions. They're questions.
They are questions.
And the problem I have is what I already identified, which is the questions seem at least relevant to a determination of credibility.
Well,
We can't exclude from the judge's consideration all the actions that the victim took. In this case, you're saying it's a victim.
Well, I think it's a fair point that inquiry to the extent the first question related to the events of that night, I'll grant you that. I do think the court could exclude the court from considering whether or not an individual filed a prior or sought a restraining order on a prior date from the court's consideration in evaluating the credibility of witnesses in this context.
Well, I mean, let me back up for a moment. When determining a person's credibility, which often revolves around motive and intent, right, a significant delay in reporting until something else kind of intervenes is often kind of a situation that a trial court judge is faced with.
Agreed.
On a daily basis, right? And so your argument may be very convincing at the trial court level, but the judge heard evidence about two different set of circumstances, had to make a credibility determination, and certainly could have chosen to order mutual restraining orders. Say, I find you credible, and I find you credible. You're both in fear of imminent serious harm, or you both have been assaulted. That happens quite often as well. But in this instance, she testified that there was first an event that happened, right? And that she was physically assaulted at that event, but she didn't go to the police and she didn't seek a restraint. She went out with friends and then called and said, hey, I get some of your items. And so when a judge is calibrating and determining, are you in reasonable fear of imminent bodily harm? And you call and say, I got your ID. I didn't mean to take it, but I have it. And I went out with friends when determining, did this happen? Is this truthful, right? The fact that hanging out with friends or contacting the police is fair game, isn't it? I mean, you can argue.
I don't disagree that questioning about the events of that night is fair game. I agree with the court on that. I think some of your questions were going towards whether her request for a restraining order should be granted. We have not pursued that on appeal. We're focusing on the grant
Right.
of the restraining order as to him and whether he either suffered harm or was in fear of imminent serious harm. Again, I won't belabor it, but I don't think the record's sufficient to support that. But on the credibility issue, I do think this court can make a determination, particularly, and I guess I'll, to acknowledge Justice Judge Englander's point, the last three questions, maybe not the first one, but the last three questions were intently focused on her failure to, there was a history of abuse here that my client testified about, that testified about prior beatings, prior being dragged by the hair, and the response from the court was, you didn't seek a restraining order in those instances. Now, and she responded, as I think the literature would show, many victims of domestic abuse respond. I was processing it. I wasn't sure what to do. And I would suggest that those questions alone are enough for this court to reverse the credibility determination. I recognize that's a rare circumstance, but I do think there are areas in the law, this arises in criminal context and rape cases, there are questions that aren't supposed to be asked, and there's factors that are not supposed to be considered, even though we may step back and say, this could be relevant, right? It's relevant, but as a public policy matter, it ought not be. So that's our position. I see my time is up. I'm happy to answer any other questions.
All right, thank you very much.
Thank you.
We'll hear from counsel for AS.
If he pleases the court, Tracy Green for AS. I would just begin by saying what the court has actually already been addressing, that essentially the entire argument posed by the defendant is premised on the fact that Judge Mishera abused his discretion when he made credibility findings when both parties were present.
Not really, no. I mean, the first argument is there's not enough evidence, right? It's not a credibility, it's not an abuse of discretion, it's really a question of law. Was there sufficient evidence that your client was afraid? Client didn't seem very afraid. He testified that, she'd been hitting him for some time, but he goes back to her apartment.
Well, I think he went back to her apartment because in essence he had no choice. And he did make that clear on the record that he was saying it's not a good idea for us to be together, I can't be with you. And he actually just wanted to meet in the lobby of her apartment building, but she was the person who essentially forced him to come up to her apartment in order to obtain these two forms of identification that she had taken from his apartment earlier that same evening because they had gotten into another argument when he said he did not want to be with her.
Right,
and
but
I would
arguments aren't a basis for a 209A. Verbal arguments are not a basis for a 209A, right?
They are not. However, he didn't just testify to the judge about verbal arguments. He indicated in the first argument that they had when she indicated that she was violently assaulted, she, as the court noted, did not go to the police. She went out with her friends. Apparently, she must not have had any injuries because she didn't mention anything about that. And then that same night is saying that she is in fear of him, yet she is having him come to her apartment and get these two forms of ID.
Right, no, I get all that. I'm focused on the question, his first question is really a question of law. Is the evidence that was submitted sufficient for the judge to conclude that either physical harm had been inflicted or that your client was in reasonable fear of imminent physical harm? I'm just making the comment that the evidence on that's kind of thin.
Well, I would argue that he actually testified to the fact that he had been physically assaulted, and verbal testimony is sufficient for the judge to find it credible if, in the context of everything else that he heard, there was actually a video of the plaintiff's apartment, which I would just argue that the context...
But the video is not about a physical assault. So the video is about arguably violent behavior by the defendant inside the apartment, right?
I would agree, but I think the context of that vandalism is important, and I would just quote from the record on page 37 of the appendix what the plaintiff said to the judge was that he testified during an argument that apparently there was a cheese board that they made together, that at that particular time, she turned on his gas stove. And he was afraid that she might be trying to burn down his apartment. Then she said, not only was she trashing my place, but she was also trying to burn this cheese board. And he had no idea if he was trying to...
Was there testimony that she physically hit him during the altercation on the 5th? I don't recall that.
There was testimony that he said in the second, there are two arguments essentially. The first argument that happened at his apartment, and then the second argument that happened at her apartment. And he had indicated to the judge that she locked the door, and so that when he was trying to leave, that he was being hit by her. And what he said is, and I'll quote again, we had to go up to her apartment. She locked the door, standing by the door, not letting me leave. At the end, I don't know what happened. She just lost her mind. Or what happened to the point that she started hitting me and trying to provoke me by saying that, quote, oh, you want to hit me, please come and hit me. And then she said, if you leave, I will jump. I would argue that in the context of those statements, the fact that he did say that she assaulted him, that was terrifying. So in one particular...
It doesn't have to be both, right? Sorry to interrupt, but it doesn't have to be both. It's prong one or prong three.
Exactly, and he doesn't even have to prove he was actually physically assaulted. He just needs to prove that he's in imminent fear of being assaulted. He testified to the judge that he was actually physically assaulted, and he was concerned that she was going to physically assault him again. So now we have evidence before the judge that essentially he's concerned that she actually was trying to burn down his either apartment or the building, and then now they get into a second argument, and when he's saying to her, I just don't want to be with you anymore, which was basically the theme of both arguments. She refuses to stop. She is the one who keeps coming after him, and he is afraid. He is afraid of what she will do to him if he does not see her anymore, and that's her intent. She's trying to manipulate him with these threatening acts to stay with him. That's the reason why we have restraining orders. He is not supposed to be in fear. He's not supposed to have to be with her, because if he's not, he's afraid she's going to physically assault him, or she's going to burn down his apartment, or that she is going to potentially hurt herself.
What about the questions from the judge?
Yeah. I would just argue that in the context of the questions from the judge, again, it was almost like part one and part two of this hearing. Part one, when he first asked the question to her, he had already heard from both parties, from her as well as her defense counsel. He gave them, as long as they wanted to give their explanations of why they believed that they should be getting a restraining order. And it's at that point that he said to counsel, did she call 911? Did she call the police? It was after he had heard from her. This is the context that the judge is posing this question. She had told him that she had had an argument with the plaintiff, and then she went out with the friends. That just doesn't make sense. People who are in fear, for their lives don't just go out with their friends later because they're trying to process things. That was her explanation to the judge. And then not only does she go out with her friends, then she is calling the plaintiff and telling him to come to her apartment to obtain these two forms of ID. So when the judge is looking at the context so when the judge poses this question to defense counsel, this is what he has heard. It's a fair question to ask, given what he heard and the fact that her actions, although she is saying that she was in fear, her actions posit an entirely different behavior. And so he had every right to question her credibility, given the fact that the first time that she said anything about this was after he took a restraining order, was attempting to take a restraining order out against her. So I would argue that given the context of what the judge heard, and he, even after he made his first findings, he allowed her to tell him some more. So he gave her utmost...
Finish the sentence, then I got a question for you.
I'm sorry, I was just going to say that he gave, both the defense counsel and the defendant the utmost time in order to explain their positions.
So if this were an appeal not from the grant of a restraining order to your client, but from the denial of the restraining order to the defendant, and the judge had said she didn't go to the police, she delayed in coming forward, I don't believe her, therefore I'm denying the order. Do you think that would be improper under the statute?
I think that if the judge had not heard testimony from her that I think anybody would be skeptical of, I would agree with you. But I think that given that was her own testimony. Her own testimony was that she is alleging that she was violently assaulted by my client. And then she goes out with friends. She does not call the police. And then she is telling him to come to her apartment. And according to her,
let me put it this way.
I would argue that she's still, just because
So
they're
are you
having
saying,
mutual arguments.
are you saying that
I don't think she met
that's
her
not
burden.
an instance of a judge denying relief solely because it wasn't filed within a particular time?
I would argue
That's the
no.
words of the statute.
That's correct, and I would,
So if the judge had said, look, you're very credible, but you waited too long, I mean, other than the fact that you waited too long to come forward,
yes.
very credible, therefore I'm denying it.
yeah, under those
So
circumstances.
that would be improper.
It would not be, if the judge found that she was credible but then didn't issue the restraining order, that would be improper, of
Or if the
course.
judge said, you waited too long, and therefore I'm not granting this relief. Wouldn't that at least be cause for a remand to clarify, well, is it solely because of the delay, or is it because the delay, I mean, what does the statute mean in making this an impermissible factor, except that delay should not be considered on the issue of credibility?
Well, I think that the court was clear to make, it's solely not supposed to be based on that. And I think that I think the fact that he issued it against her and not my client was actually a consistent finding, because he found that she was not credible.
If you could, one of the points is, you talk over us, and you've got to let us
I'm so
ask.
sorry, I
okay?
apologize.
One of the points that is coming through to me, which I hadn't focused on, is it's less relevant to your client's case. I mean, the statute actually deals with the claim that is not before us on appeal, her claim.
It's true.
Right? I mean, it has something to do with the mutual evaluation of credibility with respect to your client's claim, but it's not directly applicable to your client's claim.
You're right.
And I hadn't really focused on that until we got into the argument, which is why we do this, is to help us understand the case better.
That's essentially my argument.
Seeing no further questions, yeah, unless you're all set?
I'm all set.
Okay.
Thank you.
Thank you. Thank you both. Thanks to all three of you, I should say. All right, and our final case will be 24P 1053, Department of Children and Families versus Child One and others. And I'm sure I don't need to say this, but as just a reminder that this is an impounded case, and although the courtroom is otherwise empty, we are live streaming on Zoom, so please avoid use of names. I think we can stick with Child One, who's the younger child, and Child Two, who's the older child, if I have that correct. And we have an unusual time split, so just to clarify, Mr. Levin for Child One, 8 minutes. Ms. Grantham O'Brien for Father, 8 minutes. Ms. Diaz for Child Two, 3 minutes. And then Ms. Murphy for the department, 19 minutes. Yeah, okay, and please sit down, I'm sorry. All right, so Mr. Levin, whenever you're ready.
Thank you, Your Honor, and may it please the Court. Charles Levin for the younger child. and he's before you today requesting that the termination decree against his father be reversed and remanded for the trial judge to consider whether or not, despite his unfitness, he should nonetheless have custody of this child. It's an unusual situation. We're making this request under unusual circumstances. This
Can I
case
get
actually-
straight, can
I'm
I get
sorry.
straight at the outset, what is the department's current permanency plan for child one?
My argument, Judge, which I'll reiterate, it's in the brief as well, is they don't have a permanency plan for this child. This child has been in the same foster care placement, it's not a pre-adoptive placement, for 4 years. The permanency plans which they submitted to the court, there were several of them over time.
Yeah, but can you give me the straightest answer you can? What do they say is the plan? Has anything changed since the judge's decision?
No, and they actually don't say what their plan is. That's what I want to emphasize. They do provide information about...
It's basically adoption or guardianship. Is that
Adoption.
accurate?
Adoption is their goal.
Okay. They don't have details, I understand. But isn't what you're objecting to about the plan not so much the lack of detail as the bottom line of the plan, that adoption is just not a realistic plan given the child's age and opposition to adoption?
That is my primary argument, but it is also true that it violates the requirement under 11929B to submit a plan that a judge actually can evaluate beyond simply this is the child's needs. They did that.
Would child one be more open to guardianship if the father's rights were not terminated?
That was not established at trial. There's no record of him being open to a guardianship, nor is there any evidence that there was any guardian in sight.
He doesn't have to be open to a guardianship, though, right? As opposed to adoption.
That's true.
Right?
That's true.
Okay.
But there was no guardian identified, no potential guardian even identified throughout these proceedings.
How old is your client now?
How old?
Yeah.
13.
You know, I hadn't focused on until you stood up that, you know, your argument has two components. One argument, one piece, sort of step one is don't terminate the father's rights because the child's not going to be adopted. That's right. But
Yes.
step two is you actually want the court to consider giving the child's custody to the father,
Yes.
despite the determination the father's unfit.
The statute does allow that, and in fact, there was a decision out of this court just on April 14, adoption of Osborne, where just that precise result occurred. I believe Judge Walsh was on that case. And I think that there's very strong parallels between the two cases. If you look at
Is it a published opinion? Oswald?
Osborne, I believe it's not public. It's not
You should
published.
tell us that,
I'm sorry.
okay?
Yeah.
Tell us that before you start. I mean, it's okay. We put the darn things out on the internet, so, you know, it's okay to talk about them, but we need to know, not published.
Sure.
There's a big difference between the two with respect to how we process that internally, which is well known to everyone who understands this.
Understood. My feeling, however, about the Osborne case is that it doesn't. I'm not citing it to you today for any law, but for the analogous facts and circumstances which led the court to reverse the termination of the parent's rights, even though the parent was found unfit, because that child, like my client, had a significant bond with the parent. There wasn't a bond with the foster parent. The biological parent, like the biological parent here, was had all kinds of issues. She had.
Can I interrupt for a moment?
yes.
Sorry to do this, but when you cite to Osborne, I mean, first of all, I do recall that case because there's a recent case, an unpublished case, in which the child was severely autistic, and there was no hope. But the issue was that at least in that case, the mother wanted to continue to visit the child. And so it wasn't a question of unfitness, and we affirmed on committing and finding unfitness for the mother and committing Osborne to the custody of the department. What we terminated was what we reversed was the termination of the parental rights when there was no other option, but we didn't give back custody of Osborne to the mother under any circumstances. And
Yes, that's correct.
I thought when you argued to Justice Englander, you said, oh yeah, Osborne, we did that. We didn't. We didn't give back custody.
Right, but the reversal of the termination of parental rights was absolutely critical in that case, even though custody, it was clear that custody wasn't going to go back to that parent.
Right, but how do you argue that you give back custody to a parent who is unfit?
Well, first
Did
of all...
I hear you wrong?
First of all, the statute allows that. It's 119, Section 26B, explicitly provides for a court to
Just want to caution, you got 1 minute and 45 seconds left, so try to get to the point.
Okay.
This father... I don't mean move past Judge Walsh's question, but I'm saying you don't need to cite the statute that it's permissible. We're asking why in this case.
Yeah.
Why would we?
This father does not possess, despite unfitness, he doesn't possess the grievous shortcomings that are necessary that would present irretrievable harm to this child. He's not a dangerous person. He doesn't have a criminal record. He's not a big substance abuser. He uses marijuana. The findings are clear. He has a close bond with this kid. He always has.
All right. I want to ask you a couple of specific questions. Is there any evidence that if the father's rights aren't terminated, he would be litigious and would come back and seek review and redetermination every 6 months, or participate in the 29B hearings in a way that would be disruptive to the child?
I don't believe so, Your Honor.
I'm going to ask everyone that question, so please, if you can address it affirmatively, you'll save me the trouble.
I see no evidence in the record for that.
All right, so it's the mere possibility that DCF and apparently the judge are concerned about.
Yes.
Okay. Is there any other reason for termination other than that in the DCF's and the judge's view, this would delay or prevent the child from potentially disrupt a later placement?
There's really not. There's not a good argument from my calculation for this being considered in this child's best interest, given this child's current circumstances.
Okay. All right. And do we have any assurances or any way of getting assurances that the father won't seek to disrupt, let's say if the child were placed in a guardianship?
I don't know that there is, Your Honor, to be honest.
Okay. Thank you.
I know you're over time, but I just have to ask this question. Isn't it fair for the judge who believes that a child has an unrealistic expectation of reuniting with an unfit parent to weigh that in the calculus to say, maybe you won't be so opposed to adoption in the future?
Well, I think
because there's an unrealistic expectation that someday son and father, who obviously love each other, heartbreaking, won't be reunited, to open the possibility that the best interests of the child are served by adoption in general?
I mean, in many cases that would be absolutely true. I think, if a judge could simply do that without evidence in the record that the child would change his mind, which there is no evidence here of that, we would have a different decision, for example, in Ramona. I think you have to take the child at his word. There's reasons why he doesn't want to be adopted, and it could have more fundamentally to do with his fundamental allegiance with the biological parent, so that, he doesn't want to violate that allegiance, even if his rights are terminated.
All right. Thank you.
Thank you.
All right. We'll hear from that's your counsel for the father.
Good morning,
got some
Your
water
Honor.
there?
Oh, it's allergies, but thank you. Your Honors, Tamika O'Brien on behalf of Father. Your Honor, I only have a few minutes, so I want to get to the point. First, Father's not contesting his unfitness. We are contesting the adequacy of the adoption plan. Before I get into that argument, I think it's important to address two things before I forget. First, Justice Sachs, you had asked about the evidence of the possibility of father, disrupting the process. I obviously can't speak to whether or not he would, but I can say that in this case, it was DCF that was the party that brought all of the litigation. Father did not. He could, but he did not.
Is there any evidence or reason in the record to think that he will, if both children were placed in guardianships, is there any reason to think that he would seek to regain custody?
Not from my recollection. Clearly, this was not his preference, but from my recollection of the record, no.
Yeah. So if circumstances changed, who knows?
Correct.
But is there any way that the judge could be given assurances that he wouldn't seek to disrupt?
I don't think so.
What about, just thinking out loud, judicial estoppel? What if we were to say, and have no idea if we would do this, we're not going to terminate, but we do so on the understanding that father's not going to seek to disrupt stable placements and guardianships unless there are very materially changed circumstances. And then if the father comes back and tries to do that, then the judge says, you can't do that.
Well,
You wouldn't even be here if you hadn't promised that you weren't going to do that.
correct, but, and it's been a long time since I was a trial attorney, to get to the stage of a review and redetermination hearing, they have to prove that there's that change of circumstance. So at that point.
What about the 29B hearing? Can they, if we didn't terminate the father's rights, or if the judge didn't, would the father have a right to participate in that?
He would have the right to file an objection. Justice Walsh, you had asked about, and I don't remember the exact question, about, I think it was along the lines of if there's anything wrong with the judge basically telling the children, like, look, there's no hope. And then that kind of changing their mind somehow. And, I don't want to lose sight of my argument about the adoption plan, but something, and I was reading it this morning, Conclusion of Law 27, where the court says, the court wishes to make it clear to the boys that reunification with father is not possible. And I think that that's really important, because here we have a case where DCF does not have a viable adoption plan. The adoption plan in Varick, as loose as that was better than the adoption plan here. And the court there said that that was not adequate. So I think that the trial judge had a genuine interest in making it clear to the children that father was unfit. But that does not mean that it was in their best interest to terminate. And that is a two-part test. And, so you have the unfitness, but also the best interest. And you have these two children who, were adamant they did not want to be adopted. And that is not something that anyone should take lightly. These plans fell so far short.
But I don't know that what you just I can agree with everything you just said. I don't know that that's an answer to Judge Walsh's question.
Sure.
I mean, her question was, as I understood it, can't the judge, in deciding to terminate rights, so on the second step,
Sure.
take into consideration that termination of rights may loosen up the child's resistance to adoption, and that may be in the best interest of the child in the way the judge sees the whole dynamic. That's the question.
Sure. And again, like I said, I kind of lost sight of what exactly the question was. I think that, yes, the judge can do that, but does that mean that the judge having the best intentions here was actually in the best interest of these children? These are children, again, they've been in this system for so long. You can't tell me that no one has ever said to them, this is a possibility, and you can possibly be adopted. So I do think that the judge had the best intentions here, but that was really indicative of whether or not it was in the children's best interest. Was it in the children's best interest maybe to understand father was unfit? Yes, maybe. But was it in their best interest? Is that conclusion right there? I'm searching for the right word. I don't think that conclusion right there was in the best interest of the children. Something that I did want to mention is, we are asking that this case be remanded for consideration of a further or a better adoption plan and to vacate the termination. I do understand that under Thea.
Is it the content of the plan that you object to, or is it the bottom line?
I think it's kind of everything. We have the adoption worker, DCF. This case has been ongoing for so long that they don't even have a written adoption plan. We have 29Bs, which has a vague discussion of the children's histories, but nothing to do with their particular needs.
Has anything changed? Is there any more specificity to DCF's current permanency plan since the findings and conclusions were issued?
I don't know.
Or is it still adoption or guardianship?
Well, I believe the testimony from the adoption worker was that they were going to have a permanency planning meeting and then considering, at least for one of the children, changing the goal to guardianship, which we don't need a termination for guardianship. I think that... You don't know whether, that was about 2 years ago that testimony occurred, or maybe even 3. Right. So I don't know. I think that probably my sister could speak a little bit better to that. But, again, in Thea, an inadequate adoption plan does not necessitate vacating termination. But here, given that the court had other options, especially when DCF adoption worker was saying, look, we're considering changing the goal to guardianship, I don't think that termination was absolutely necessary in this case. And I think that we have to hold DCF, the government who is in charge of these children, to task. They have to do their job, and they have to file an adequate adoption plan that is considering the special or this unique needs of these children, and who's the adoptive home and families that would best meet those needs.
So the adoption plan that's in the record is, the most recent one is from April or May of 2021, if I remember correctly, is that right?
That sounds about right.
And then the judge is permitted under the cases to kind of supplement that with testimony at trial?
Correct.
Okay. But there's nothing more recent than what's now 4 years ago?
I can't say yes or no.
So your client didn't appeal. So what do we do with that?
So, Your Honor, this was my error, not my client's error. I had, and I'm sorry, I'm embarrassed to say this, but I had thought I filed it, the e-filing system. My sister had emailed me, and I sent her a copy in December.
We're talking about a failure on the docketing side, right? Not the notice of appeal is timely filed, if I'm remembering this right.
Correct.
Docketing, and you're saying, I just blew it.
I'm saying I made a mistake, but I'm not arguing that the father's unfitness. I am more supporting the children's best interest arguments.
Well, no, look, I want to understand what happened, and what you think we should do about it, I suppose, is the second question. So when this is, having been single justice recently, I know we have a standard order that comes out, and the order says, you didn't docket on time. You now need to, one, tell me you've got a non-frivolous argument, and two, give us excusable neglect. But what I read in the briefs was that didn't happen. There was not a filing in response to the order that came from the single justice. Is that right?
That's not my recollection.
To refresh your memory, I believe that there was a statement in the single justice to bring it to the panel's discretion as to whether or not to allow the late filing, right?
Correct.
Okay. Okay. Because, counsel, I've seen you before, and I know you do a very nice job. And so I wanted to understand what had happened.
I appreciate the generosity in that statement, sir. Thank you, Your Honors. Thank you.
Thank you. All right, we'll hear from Attorney Diaz for Child 2.
Good morning, Your Honors. Myrna Diaz, may it please the court. Your Honor, I have the second child in this case. He is currently 15 years old. He has been in the same foster home for about a year or so now. I met with him recently, asking him again if his position has changed, as it tends to do with children. And as of right now, his position is that he does not want to be in a guardianship. He does not want to be adopted. To answer Your Honor's questions about whether or not there is anything current regarding the plan, if I can go outside of the record, I did inquire with him and with the current foster parent as to whether or not they have been spoken to about a proposal regarding a guardianship, and that answer was no. So right now there is, as my understanding, there is no current plan for my particular client. Regarding the...
I just want to make sure I understand. So he had been placed, as of the time of the trial decision, in a comprehensive foster home with a family that was open to guardianship but not adoption.
That is correct.
Okay, I thought I understood at the time that he might be open to guardianship.
That is correct.
Although, as Justice Englander points out, he doesn't
Right.
need to, he can't veto that like he can
Right,
veto.
so he was open to it, and what happened was he had been then moved to another home.
So he's been in another home for now about a year.
Time out. Oh, okay.
Okay.
So your client, as I recall,
Yes.
had been with a family for roughly 4 years.
I think it was a little less than 4 years, Your Honor, but he had been there, and I'm sorry if I'm misquoting
Anyway,
I won't argue that. It's not.
those circumstances have now changed
Yes, Your Honor.
since the briefs were filed.
No, Your Honor. When I was assigned to the case 6 months after the judgment, in my looking for my client, I was looking for him in the foster home he had been placed in at the time of trial. And then he was moved to another home. And then I was finally able to locate him there.
What state is your client in?
He's in Massachusetts. Yes, he's still in Massachusetts.
So he's been with the current foster home for
Yes.
how long?
I would say close to almost a year and a half. He's been in that same home.
Do you, could you just address whether there's a risk that if the father's rights weren't terminated, he would seek to disrupt an otherwise stable placement?
So I know I addressed this in my brief, Your Honors. So there is nothing in the records that show that father is litigious. Since this case went to judgment and since the rights have been terminated, there is nothing that I am aware of that has occurred in the lower court of father having filed anything with his trial attorney regarding the disruption, or besides the notice of appeal, obviously. There is nothing in the record that states that father would look to disrupt the guardianship. And just to address something I forgot which of Your Honors asked about whether or not there could be some kind of order from a judge saying that, you know, if there is a guardianship in place, the father won't come in and disrupt it in a certain amount of time. I know that there are agreements that can be made in which there can be a written stipulation that there will be a guardianship in place, and, you know, father won't come in and disrupt the guardianship for X amount of time. So that is something that can be done, and something that a parent could stipulate to if they were open to, and obviously if a court were to agree to do something like that.
All right.
Nothing further. I rest on my brief. Sorry, but there's no more questions from the panel.
I think we have to leave it there.
Okay,
All
thank
right,
you.
thank you very much. All right, Attorney Murphy.
Good morning, may it please the court. Lynn Murphy for the Department of Children and Family. Just want to say for the record, the department objects to two of the appellants here. One did not file a notice of appeal, and as you notice, the other one did not docket the appeal. That being said, the department asks you to affirm the termination of parental rights. No one is...
Can we just stop there for a moment? I don't want to take a lot of your time on it, but I did some noodling on this in my head, and I'm thinking, you know, let's take the younger child. The younger child says, I object to my father's parental rights being terminated. Isn't that enough anyway, even if father doesn't appeal?
Enough for
that issue to be properly before
Oh,
us
absolutely.
and for us to be able to reverse it.
Right, I'm not saying that the issues are not properly before you. I'm just saying procedurally speaking, two of the appellants have not complied with the rules of appellate procedure.
Yeah.
That's all I'm saying. But the department has addressed the arguments, and luckily, because the briefs were filed after I filed my brief, but a lot of it was contained in my response that I filed to younger child J. So again, the unfitness here, we're talking about.
So you're not objecting, I want to get this on the record. The department does not object to us addressing whether or not the father's rights were properly terminated.
Absolutely not. That was
Okay.
raised in the younger child's brief. And I'm ready to address that also.
What is the current permanency plan for either of the children?
The permanency plans remain pretty much the same as trial. The department is seeking permanency through guardianship or adoption.
Okay. And if I'm correct, please tell me if I'm not, the most recent written plan is from April or May of 2021. It's at Record Appendix 737, and there's a brief statement at 740 that says the plan is for adoption, I think. And then it is supplemented by the testimony at trial.
On the record before you, that is correct.
Okay. But the judge doesn't seem to make findings about whether the current plan leans more toward adoption, accepts that adoption seems unlikely in light of the both boys' opposition. All we have is the testimony of the adoption social worker, and the judge is basically approving the plan without saying exactly what she finds it to be.
Well, the judge made 28 separate findings for each child, detailing the child's special needs.
Yeah, okay, but what we want to know about is what is the bottom line of the plan. I understand that there is, I'm not so much concerned about the content of the plan now, like what kind of family or parent would be best for adoption or guardianship or other placement, but whether to, which of those to seek and whether it's realistic to seek adoption.
I'm not sure I'm following you. You wanted the judge.
Is it realistic? Is there any finding by the judge that adoption is a realistic possibility for either of these children, given their opposition to adoption?
The judge notes the child's preferences. There were findings and consideration on that point, and that the children, as counsel just said a few seconds ago, these are children. They change their mind. That's exactly
But they haven't changed their mind for about 4 years. Is that accurate? I mean, at least as of the time of trial, they had opposed adoption for some time.
They opposed adoption, but they were open to guardianship.
Yeah.
So the fact guardianship is still a permanency plan. Adoption is always the goal and the preference, but guardianship is just as permanent as long as we have termination of parental rights.
Termination is not a prerequisite to guardianship, correct?
If you do not have it, there is a, pardon me, that leaves open the parent to challenge that guardianship.
Okay, so is that the only reason the department wants to terminate, is to increase the possibility of successful guardianships?
The judge and the department were very clear. We want stability and permanency. This is a father that could, for 11 years, could not provide consistency and permanency at a certain point.
Okay, got it. That goes to unfitness.
And termination.
But what goal would termination serve here?
Termination provides a chance for permanency and stability.
Okay, but guardianship provides a chance for permanency.
Not with parental rights intact.
Okay, so is there reason to think that the father is going to disrupt a successful, stable
Yes,
guardianship
there
or
is.
foster care?
Absolutely.
What is it?
On the docket sheet, you will notice there were motions to dismiss the care and protection petition. This case has been litigated heavily over 11 years. Father has not been passive.
When was the last motion to dismiss?
I would have to check the record. I think there could even be two, but there was one, I believe, around 2015, 2017. But he has been an active party. It is not only the department who has been moving to reinstate the CMPs. And I will again point out, these children have been traumatized by being removed and replaced with father 5 and 6 times over 11 years. The department has bent over backwards to provide services. As we heard, the expert testified, in his 35 years, he had not seen so much effort be put into addressing the fathers in fitness. He could not do it. He was unable to provide any permanency for these children and to continue this in and out situation that has traumatized the children.
But we're not here about unfitness. I understand that when you look at best interests, oftentimes there are overlapping elements, right?
Right.
But when you look at the adoption of Nancy, right? And in that case, the court said, well, there are instances in which to ease the children, right? And because of
ease the
the
road
fact
to
that,
permanency, I think.
right,
is the-
and so permanency, stability, but those children had a bond with their foster placement. Those children had stability for a number of years, and we've just heard that in one instance, we have a relatively new living plan, right? So where before there was a track record of 4 years for one child, that no longer exists. Now they're at another home. And so the case doesn't square on all fours with adoption of Nancy, where the judge could say, children deserve permanence and stability, here they have it, because it doesn't really seem that they have that, do they?
They have not, or have we reached the final goal? The department continues to work forward. There are, again, these are significant special needs, and we're working with 2 children who have changed their opinion about what kind of plan, what kind of permanency they wish. But again, all of these issues can be addressed. In fact, there's a permanency hearing scheduled for June 10th in this case. Children can show up at that time and tell the judge any considerations or concerns that they have at that point, and that can be addressed. And this is,
While the case is under appeal, does the father, yeah. I was about to say, while the case is under appeal, does the father have rights to appear at the permanency plan? And then I thought to myself, well, it's not all that clear. The father's appealed. Would the father have rights if he had appealed to show up at the permanency plan, even though his rights are terminated?
No, once they're, my understanding is, and I can't remember a situation where this has happened, but until that decree is overturned, the father would not have any input. But the children are represented by...
So your position is that the father cannot participate at the upcoming 29B hearing?
Yes, right, with termination of parental rights intact.
Okay.
But
Even though termination is still...
because the decree is still on, that would be my...
Still subject to being overturned on the child one's
is.
appeal?
Right, right.
Okay. So in conclusion of Law 27, the judge says that termination of parental rights in no way severs the emotional bond between the boys and their father.
Right, yes.
Is that a tenable statement?
Yes, because at that point, the judge provided to continue that emotional bond through a generous order for post-adoption visitation.
Yes, but does the fact that does the father remaining the legal parent of the child contribute to the emotional bond, or is it irrelevant to the emotional bond?
I think a father he's always going to be the father. The fact that he has no legal...
Well, unless the law terminates his status as a father.
Well, that's a legal status.
What concerns me is that the cases say termination is an extreme step that shouldn't be taken unless the child's welfare demands it. And I'm having a hard time seeing how either child's welfare demands it here, where the prospects of adoption seem extremely limited and other placements that could be stable don't require termination.
I would answer that
My
by,
fundamental problem with this.
and I would answer that by saying something that the trial court was most concerned with. She did not want these children to have false hopes of reunification. That was one of her main thrusts. We need to terminate because we don't want these traumatized children to have false hope. There cannot be reunification here. I think I can say that pretty, I think the record.
Is there evidence of that they would entertain false hopes, or is that just a kind of a generalized concern?
That was based on the testimony presented at trial.
But what testimony
The
suggested
social
they would
worker-
have false hopes?
The false hope was the children kept saying they were against, particularly the younger child, when we tried to place the younger child with one of the other foster placements. Child was very not open, completely closed, I should say, to the entire idea of it. So the judge made this inference based on that evidence,
I
testimony.
take it the children didn't testify.
No, they did not.
Okay,
They did
so
not.
the evidence before the judge would be from the social workers' references to what the children had said.
Right, and
That was largely undisputed, what the
Yes.
children's position was, correct?
at the time of trial,
Yeah.
yes, it was clear that one child was open to guardianship at that time, and the hope was the other child would also be open, but he was more close-minded. The younger child was more close-minded. So yes,
So-
that was established without significant contest.
The adoption social worker testified that continuing to push child one to consider adoption can definitely have a negative effect on him. Did the judge take that into account?
I'm sorry, could you say that again? The
Yeah.
social worker?
The adoption social worker testified that continuing to push child one to consider adoption can definitely have a negative effect on him.
Right.
That's transcript 687. Did the judge consider that?
Well, I think what was happening there was the social worker was trying to present to the court the difficulties. So yes, his department was pursuing guardianship and adoption for that very reason, because we cannot, to force a child would not be in their best interest. And I would have to look at the findings again. I'm sure the judge considered that. The judge absolutely considered the child's wishes, as stated at trial.
But this is different from the child's wishes. This is what the department is doing,
Right.
affirmatively harming the child.
Oh, the department was open to adoption and guardianship for permanency for this child.
Okay.
We know the child has significant special needs, including a trauma history that was testified to a number of times. So the
Okay.
department's
So there
not
was
gonna-
no evidence that, that seeking guardianships for either child would harm them, the way there was testimony from the social worker Scott, I think, that pushing child one to consider adoption repeatedly would definitely be harmful, definitely have a negative effect.
It is very challenging to deal with teenage children with a trauma history, with extensive special needs, and a vacillating idea of where their permanency, where they want to be permanently.
Has there really been that much vacillation?
Yes,
So-
I think so, particularly for the older child, M, absolutely. And the younger child,
How has the child vacillated? He was open to guardianship, I think, in his prior placement, but he no longer is open in his current placement? Is that,
I mean...
is that what you're referring to as
I'm referring to the
vacillation?
fact that the child M was an appellee in this matter until just recently now is no longer an
Well,
appellee.
child
So we have a
one
situation...
still has child two still has the formal status of an appellee. But
But my point being, the child changed his mind.
what did he
Again,
change his mind about?
Whatever counsel is presenting to you. I think she's saying that he doesn't want either. Wants to return to the
You mean that
father.
he didn't originally appeal and now he's asking
Right,
us to
right,
grant relief?
exactly.
Okay, but not appealing is not definite, a clear statement of a position that I'm comfortable with the trial court's. I accept the trial court's decision to terminate. Is it?
I think the reason that we accept the termination decree here is because it was in the child's best interest. The judge specifically made findings that the hopes, to have false hopes for these children after this much, many years and this much trauma was not something she wanted to do. Children do change their minds. In Vito, the court notes the twists and turns of, as children grow up. That's why we have the permanency hearings. The system, the statutory system is set up to review it again.
Yeah.
And
So
we have judicial oversight on that issue. That's why we have the permanency hearings.
Is there a way to make clear that reunification is not possible while still not terminating parental rights? In other words, you know, it doesn't look like an adoption is in the cards for either child, and the older they get, and they're very resistant to it, it really doesn't seem realistic. But guardianship or a stable foster placement is possible. So,
Guardianship or...
right. Is termination going to make that more likely?
Yes.
And
Absolutely, because people are reluctant to be a permanency source for children whose parents' rights are still intact and child could be removed.
Without going too far outside the record, can we say why child two's apparently stable foster placement is no longer in place?
Again, we have significant special needs. I don't know what the reasoning. The child's been in, as counsel said, a year and a half. And again, this will be reviewed on June 10th. All this.
How often do they have to have the permanency by statute?
They're supposed to have them at least yearly, but you could have more frequently. In this case, not only is one scheduled for June 10th, there's another one scheduled for September.
Is it your position that the plans are adequate under Varick?
Yes,
Plans that,
absolutely.
well, what do they say? They say none of the things that Varick wants. We haven't even talked about, you know, sort of the detail of what kind of an adoptive resource you would be looking for. What, you know, what is the nature of the place that you would want the child to be placed? None of that's in, do you agree with me, none of that's in what we previously had as permanency plans?
Well, I think the problem with Varick was the needs of the child were not specifically shown by the department, adequately shown. And again, here we have 28 findings of fact for each child.
And those get incorporated into your permanency plans?
Well, those findings of facts are based on the evidence the department presented through through testimony of its workers and several reports. So those findings are and none are challenged.
Should a permanency plan address the likelihood or the practicality of achieving the department's permanency goals? So if the statement is, and I think the social worker statement at trial was, if adoption doesn't work out, we'll be pursuing a guardianship. Should the judge make a finding about whether adoption, based on the evidence before her, is likely to work?
I hope not, because that would be a very limited finding. And remember, the adoption plan is a snapshot in time.
Limited or limiting? Sorry.
It would be limiting. And I think the whole problem with that is when we go to trial, that's a snapshot of what we're doing for that child at that time. So the court can see, what are you doing for the child department? And we say, this is what we're doing. Here's the needs. We're trying to make a good placement.
Doesn't the plan have to have some basis in reality? I mean, if you
right, well, I think if it was ridiculous.
Let me just finish the thought. Yeah, right, if it's ridiculous, but let's take it back a notch. If it's something that a reasonable person would look at and say, it's not going to happen. It's not going to happen. Now, I'm not saying that I've reached that conclusion or that I even would have a basis for reaching that conclusion in this case, but I'm trying to find, I mean, I am interested in what Judge Sachs just asked you, which is, the department's putting together a permanency plan. They shouldn't write something that they really believe they can't accomplish, should they?
Oh, the department absolutely believed it could accomplish that goal, and we have. The difficulty is you can't tell who will come forward. A lot of children who have significant special needs, we have found placements for them. We don't want to give up and just not try to continue with permanency. You never know, and maintaining parental rights puts a burden or another hurdle before the court. So
is your argument? I'm sorry to interrupt, but I'm really trying to understand. These are hard cases, right? It seems to me that what you're saying is the judge came to the conclusion that it would make a big difference in whether or not an adoption or a guardianship actually happens here, to terminate the father's rights and let the children know, father's rights are terminated, you're not going back to the father. That's really the crux of the argument, isn't it?
And the father's unfitness and inability for the children to return. So yes,
Yeah, I
those
mean,
two
the latter part
factors.
we take as a given for, I mean, the thrust of the questions here have to go to whether it was appropriate to terminate the parents' rights.
Right.
Where one child is saying, I don't want to be adopted ever.
Right.
And the other one is resistant to it. So that, you know, and they're both saying, and I'd really like to be with my dad. I like my dad, and I want to be with my dad.
Children often.
And, you know, I guess what's on my mind is how far down this road do the judge's findings have to go to help us understand that thinking? You know, and maybe it's that one sentence that's been pulled out that says that I want the children to know that they're not going to return to their father.
It was the false hopes. The judge was very clear. I want these children to move on. There is no possibility for these children to be reunified with his father. His unfitness, as everyone knows, is significant. And there would be a risk. The judge makes numerous findings and conclusions about how risky and harmful it would be to return. Reunification is not on the table. The judge wanted to be very clear to the children about that piece so they could move on and the department could find permanency for them. I see my time has expired, so if there are no further questions, I'll rest on my brief.
All right. Thank you very much. Thank you to all of you for good presentations on a difficult case.
Agreed. Thanks to all.
Thank you to our court staff and law clerks for assistance today, and with that, we're adjourned.